First, I want to thank those that put this together. I'm very happy to be in Lisbon. Happier to be here than in the U.S. at the moment. So this panel today will be about U.S. class actions, a very broad topic. We hope to cover some specific areas and then some more broad areas. Obviously, we can't cover everything. So as I was introduced, I lead the mass torts and complex litigation practice at Alvarez and Marsal. And we're focused on more of the complex, difficult to allocate funds type of class actions, and of course, mass tort cases. So with that, I'll turn it over to the panel to introduce themselves.
Sure, thank you. Craig Reiser, I'm a partner at Axinn, and I focus principally on high-stakes litigation and on the defense side of class actions and other multi-district litigations, including some of the biggest multi-district litigations currently pending in the United States.
Good morning, everyone. I think I know many of you in the room, but my name's Dave White. I run our U.S. class action payments business for Blackhawk Network. For those who aren't familiar with us, Blackhawk Network is a global payments provider where we issue digital and alternative payment options for consumer class settlements. And we work with many of the administrators and law firms in the industry in the States as well as abroad.
Good morning. My name is Michael Naaman from Coherent Economics. I'm a senior economist. I have my PhD in economics. I've also been trained in statistics. I typically work on the plaintiff side, either supporting expert witnesses or expert witness myself, typically in privacy and liability type product cases. And that's about it.
Great. So we hope to have we have good coverage here on the spectrum of, from the litigation to the actual settlement to distribution here on the panel. So we hope to cover it, quickly but broadly. Just to set the table, class actions in the U.S. in 2023 collectively topped $51.4 billion in distributions in 2023. That was down a little bit from, or down a little bit from 22, but still on track to have what we would expect to be a higher trend as we go forward. The largest settlement in 23 was $12.5 billion. 10 years ago, it was about 1.1. So things have been moving at a pretty rapid pace. Product liability cases are still the vast majority of the dollars in settlement value. And then next to that is antitrust and securities class action cases. While it's not in the top three, privacy cases seem to be the most, or trending the highest across the board with the most in terms of volume. And then we also see a trend broadening outside of the traditional areas like product liability. So we're seeing class actions across, virtually all industries in the U.S., most industries. So it's not, just concentrated to one area like it had been for years. And then finally, if you sum the top 5 class actions in the U.S. in 2023, the total fees paid to attorneys is about $1.4 billion, and that's an average of $280 million per case for plaintiff attorneys involved in class actions. So I just wanted to set the table there, just to provide the scope of the industry. It's a mature industry in the U.S. With that, I'll ask the first question of the panel, which involves regulation. So the DOJ and others are very keen recently on getting involved with regulating a variety of companies. And the first question I'll ask is, how do you see regulation affecting kind of the approach to class action litigation in light of the recent election?
Ooh. Maybe I'll jump in on that. I think obviously it remains to be seen in large part, but I do think, generally what I've seen in my practice, especially in the antitrust space where I handle a lot of class action defense, is you get a complaint or an investigation started by the government, and then suddenly you have a plaintiff's firm file a complaint against the defendant in the space, and it sort of just cascades from there. So oftentimes the regulatory environment is the impetus for private class actions and potentially private AG, state attorneys general suits as well. So the question really becomes, what's the focus of the next administration going to be? And I think, as I said, it remains to be seen in large part. I think what's clear to me, at least, is that tech will remain in focus. A lot of the big tech investigations that started in DOJ that are still ongoing, some of which I'm involved in, were started under the Trump administration. And I don't expect that to change, though I think the remedies sought might be different than those that might be sought under the current Biden administration. I think the other thing that I would expect is a focus perhaps less so than we might see under Biden on AI as an area to explore. But generally, I don't expect the focus on tech to change, save for what I just said on AI. But I'm making an educated guess because I do think we have to wait and see what happens.
I think, we have some pretty good ideas. Oh, do we have a question?
Yeah, I'd like to hear how that answer is affected by the appointment of Elon Musk as a cabinet member.
Well, I read that this morning on the way here. I don't know that he's a cabinet member. I think he's the head of the Department of Governmental Efficiency.
Which doesn't exist yet. But he may become a cabinet member, and that may have an effect on antitrust, but
At least technology.
But I doubt it. I think what's going to matter more are the appointments that the Trump administration is going to change. For example, Lina Khan is the current head of the FTC, and she's definitely going to be out. And then if you look, this is a CNN headline from yesterday. A deal-making frenzy is on the horizon as Biden's top trust buster faces the end of her tenure. And what I think that means is mergers. You're going to see a lot more mergers in the U.S. over the next 4 years. I agree that tech is still going to be pursued by the Republicans because for some reason the Republicans think that the tech firms are against them. I'm not sure that that's actually true, but I think they have a bit of a chip on their shoulder against the tech firms. So I think that'll continue. But overall, I think you can expect decreased antitrust enforcement. Biden's merger guidelines from 2023 are likely to be overturned, and you're going to see a much more fruitful environment for mergers to occur. We worked for the FTC on the Amgen Horizon case, and we got a fair number of concessions that made it a much more reasonable merger. But I think you're not going to see that over the next 4 years nearly as much. A lot more things are going to go through, but maybe the European Union, maybe some of y'all can take on the fight if you see that some of these mergers are creating antitrust issues, because these firms are global now. It's not just an American market anymore.
Yeah. Good.
Yeah, I would just add, as it pertains to Elon in particular, I think there is a perception among some in Washington that there's a distinction between X and Rumble on the one hand and everyone else in tech. Whether that's warranted or not, I can't say. That's not my area of expertise. But I don't expect big tech to be out of the crosshairs so much as the remedies sought perhaps to be different. Instead of, for example, trying to get divestitures of businesses or break up big companies, perhaps large civil penalties or the like. That's, again, just an educated guess about what I think is likely to happen. But I agree with Michael that it will stay in focus.
Yep. And just a slightly different angle on that, perhaps further downstream. I can't comment on what's going to happen. Craig, I agree with you that we'll wait and see. But from a regulatory perspective, even in the last 5 years, what we've seen in the U.S. as it relates to the class members and the overall process that they are put through and ultimately getting funds into their hands, we've seen regulators promote and encourage the entire supply chain to make it an easier process to increase acceptance of the payment, which sounds funny, but if you go back 5 years, and Tim, you had an example where the U.S. was still largely issuing checks. In fact, to an extent today, there's still a lot of checks issued. So if you look at a settlement that has 20 million checks, some of them valued at less than $1, it actually costs the class more to issue those payments than it does for the value in them, and people weren't cashing them. So what we've seen is regulators asking for additional digital options, additional choices such as PayPal, Venmo, direct to debit, ACH, those types of things. And then the second part of that is serving the unbanked and the underbanked segments of these classes, which to those of us in this room may be a slightly foreign concept. I imagine most of us have a proper bank account and we can transact business electronically or by paper check if needed. But in the US, roughly 20% of the population does not have a traditional banking relationship. So we've seen regulators push in a direction of offering alternate choices, such as a digital gift card, a digital prepaid card. And as these settlements come to bear and actually settle, we see that as an important step going forward, both in the States as well as abroad.
So we'll shift quickly, since you brought it up, to distribution, and then come back to some things. The case you're referring to was a case that we worked on, and we did send checks for 2, 3, 4, 5 cents, and we paid postage of $1. That's real. That did happen.
That's real.
And we sent 20 million checks out, and that's the way. Some of the checks were close to $1 million for companies. Others were literally 3, 4, 5 cents. People that got those checks went on Facebook, went on YouTube, and held the checks up to say, "Is this real?" It was a settlement with a very large telecom company. So that checks are still very much part of how we distribute funds in the U.S. Part of it is, that's an anomaly in the sense that it's small value. Usually they're done for larger average value settlements, but it is still a very more or less archaic, but used quite frequently in the U.S. So when we talk about distribution, one of the things that we're seeing, or that we would assume, is an increase in potential, I'll use the word fraud, but it could be, maybe that's a strong word, but essentially more fraudulent, more activity around claims that are made that are not valid, and an increase in fraud based on an increase just in volume. So let's go to that really quick and talk a little bit about how fraud influences, or what are the challenges related to fraud in the distribution to class action settlements.
It's interesting, and I can speak to the second half of that in terms of the fraud that's recognized when a payment is received and accepted. But it really starts with the class registration or the claimant process, whereas the use of technology, the use of worldwide communications now have significantly increased the number of fraudulent applications that these settlements have seen. And the administrators in the room have all done a fabulous job of increasing their use of technology, use of AI, use of lots of different fraud filtering procedures to filter out claimants that aren't legitimate. And when I say claimants that aren't legitimate, this isn't an individual that I'm going to submit twice and see if I get paid twice. These are institutions that are in fraud rings in China and Russia and other places in the world where it's not only not prohibited but maybe encouraged to defraud some of these settlements. So the filters that are done when the application is reviewed is significant. But then when a company like ours receives a payment file, there's additional data points that we collect in terms of where that payment, whatever the payment type is, where it's registered, where it's claimed from, where it's spent. And you can triangulate on a lot of this information and then work with the administrator or whomever is managing the class itself to identify additional and filter against fraud that's obvious and increasing significantly in recent years. So I see that as a very important trend with this going forward on a global level.
Mm-hmm. And the use of technology with respect to fraud, is there, do you see any trends in terms of what's working, what's not?
Well, I can't. So yes, so some of that's part of the secret sauce. But in general sense, triangulating the data of who is supposed to be getting paid. They were approved and they were named in the class, and then who is actually getting paid. Is it somebody, a bad actor, trying to take money from a good individual, or was the individual a bad actor in the first place? And are they trying to spend money or siphon money or launder money to an organization that now all of a sudden that's our fiduciary responsibility to step in and prevent money laundering and supporting foreign nationals and potential terrorist organizations and things like that. So marrying together all of the data points that now exist because a lot of these payments can be made digitally and a lot of the claims are made digitally. So marrying those data points together is a big piece of this.
Yeah, and I guess on that point, I wanted to ask also that how important, and we're seeing this even though we are sending checks still to a large degree, we're seeing cases where folks are getting options for distribution. And what do you see that as the kind of the future of where this is going?
Absolutely. So it's not uncommon to offer still checks as a last option, albeit an expensive one and one that it's inconvenient for most people, even if they do have a mechanism to cash that check. But we find that when you offer choices of digital options such as PayPal or Venmo or direct to debit, where people are accepting those much more frequently because it's faster and it's more secure. Now, for the segment of the population that is unbanked, we see digital MasterCards as an excellent choice. Digital gift cards can be also a popular choice, and some of those, in fact, all of those offer a savings to the settlement because you eliminate postage, you eliminate time, and more importantly, you eliminate the non-acceptance that happens with a traditional mailed payment. Whereas it's just because it's mailed doesn't mean it was cashed, doesn't mean that it was accepted. And you mail somebody a 3-cent check and they don't cash it, well, does the settlement really get the recognition for that? And then what? What do you do with the extra 3 cents when the check goes uncashed? So the digital payments in that sense have significantly improved that process over the last so many years. And we see that continuing throughout the world.
Surprisingly, in the case that you mentioned that I commented on with these 3-cent checks, we saw a 50% cashing rate because of phones. So people were cashing these checks because they could take pictures of them and they didn't have to go to banks. So 50% is a pretty good rate on checks, so even for that volume. So any other comments on the distribution channel? I'm going to shift a little bit.
I had one question. Do you have a sense of the size of the fraud problem? Is it larger, for example, than credit card companies may face in terms of fraudulent claims, or is it less, or do you have a sense of the scale of the problem?
So it's I would say it's certainly contained as it would be, or it's being managed the same as it would be with credit cards or debit cards or things like that. It's hard to say if it's larger or not, as a lot of that data is not readily available. I would say it's increased in the sense of what we've seen 5 years ago versus what we see today. We see, when all of a sudden you see 400 payments being liquidated from the same IP address in a 2-second period of time, it's like, okay, that's not an individual that's doing that. So as a percentage, it's still a small percentage of the total. But the dollars can be significant, so it's something that the industry is very focused on continuing to prevent and make sure that these bad actors don't continue to gain traction. So
we're going to shift a little bit, a little earlier in the life cycle of the class action and talk about opt-outs. It appears there's a trend, at least in securities class actions, that there's an increase in opt-outs, an increase of people deciding to take a direct action against the company. They'll get more rather than joining a class. So the question is, why is that happening, and what kind of an impact will that have on how these get resolved in the future?
Yeah, I could start with some reactions to that. I mean, first of all, I think it's across disciplines. That's been my observation in practice, whether it's securities or antitrust or really anything else. I think there has been a proliferation of opt-outs, and what we're really talking about here are large corporations that get to sit around, watch for 3 to 5 years as these cases tick along and see what happens, and they don't have to bring their own claim or face a time bar because there's a doctrine in the United States called American Pipe that says that absent class members basically get to benefit from tolling while a class action that is representing their interests is pending. So what I've seen is that you'll see a large number of opt-out years into these litigations, some of which could span, I have one that's been going on for almost a decade at this point and isn't close to finality. And they will bring their own claim, and at that point, you'll just see them demanding more money at the settlement table if you ever get to that point. But you can have, as upwards of hundreds of direct action plaintiffs who bring their own claims, opting out of classes. And in terms of why this is happening, we don't always have complete transparency because some jurisdictions don't permit disclosure of it, but my belief is it's because of litigation funding. And you have more of an incentive as a large corporate to opt out with the benefit of funding and the benefit of time, seeing how the case is shaking out, how the judge is ruling on key issues, and it also gives the funder a little bit of a sense of what the ROI is likely to be if the case proceeds. So that is what I think is happening and why.
I mean, I think that's really only one part of the story. I mean, sure, funding allows you to diversify risk and maybe take some leaps you might not otherwise, but I think that's only part of the story. Another part of the story is, if you have a class action lawsuit, the lawyers are going to get paid 10 to 15% of the settlement claim. And then out of that 10 to 15%, they're going to pay their fees to the consultants like me. And so that puts a cap on how much they're willing to spend. And that can reduce the quality of the work. And also, class actions face a higher legal bar. You have to go through additional legal hoops for a class action that you don't have to with a direct action. So when you have a big claim, it starts to make sense to hire your own experts and have your own litigators. And you end up with cases where a class action may not get certified, but the direct action goes forward. And I've worked on cases like that, and you can still get paid on that. I think that's a big driver. I think plaintiffs and opt-outs have been winning more and more frequently. And as these firms have seen that the likelihood of success has gone up, they're more willing to opt out and put in the extra money. And I think that's been the biggest dynamic that I've seen. Now, when you add in the funding, that's like adding the gasoline on the fire, and that makes it go even more. But I think there's other structural issues involved that make it very attractive to opt out if you have a big claim. And a lot of our work has shifted from class action to opt-outs because an opt-out's willing to pay more money because they get 100% of the claim, not 10 to 15% of the damages. And so I think that's really important as well.
Well, the opt-outs are certainly always, at least if you have a settlement discussion, looking for a premium on what the class that they've opted out of by bringing their own claim are looking for. So certainly that's true that they do want more money. So I would agree with that, Michael.
Well, at least one point of agreement.
Yeah. Well, I think we do. I would agree too that it's gasoline on the fire when we're talking about funding leading to the proliferation or being one of the reasons of the proliferation for it. But the other thing I would say is, in antitrust cases in particular, and especially after Supreme Court cases like Comcast, it's not, unfortunately, particularly difficult in my estimation to establish the factors for class certification under Rule 23A and 23B3, which is usually the vehicle, as we heard yesterday, for pursuing damages as a class. I do think that, especially in that light in the antitrust space, funding is, maybe a little bit even more than the gasoline on the fire and maybe the fire itself.
I mean, I think Comcast has made it harder, not easier for class action lawsuits. When we speak with our attorneys, they fear Comcast. And just as a recap, you can correct me if I'm getting the legal details wrong, but this was a lawsuit in the United States. And the end result of the lawsuit is the Supreme Court ruled that the expert's model has to tightly fit the legal theory. If there's different prongs of the legal theory, that model needs to match that, and if it doesn't, it can be thrown out. And I think that made it a lot harder on a lot of the plaintiffs and forced us to do a better job, because I think that makes sense, is your model should match the legal theory. And if it doesn't, you should get it thrown out. But when you do that, that raises the cost. And as you raise the quality of the models of the plaintiff's team, for example, in the Google antitrust case in the United States, they hired Nobel Prize winner Paul Milgrom. And that you have to sort of lift your game up to try to match that. And he's excellent, and he did an excellent job in that case. I think they'll probably do well. But you also have the other side of the case, which is the search case. Now, in that case, he didn't weigh in on that because he's an auction expert. But on the search case, the government's already sort of won and seen that Google's a monopolist. And that's that was a big victory for plaintiffs. I think it's going to go the other way in the ad tech case. In the ad tech case, the government, I don't think, did nearly as good a job of showing that that Google tried to stifle competition, and that's where Paul Milgrom came in, and he did an excellent job.
Yeah, I guess I should note we're sort of on opposite sides of the Google case. I'm defending Google in connection with the ad tech cases, and Michael is working on the other side. But as for Comcast, just to address Michael's point, yes, it did make it harder, because you do have to have a connection between the damages claimed and the antitrust theory in an antitrust case. But the way it has been applied, much to the chagrin of defense practitioners like me in the lower courts, is not to require as much rigor as I think we might hope. It has been, in my experience, relatively, it's not as hard as I think it ought to be to certify a damages class on the basis of a damages model, and to establish that all or nearly all class members were impacted by the alleged misconduct, and that you can calculate damages in a uniform way. I'm glad that you're spending more time, because that's good, good for business, I guess, right? But I do think it's not as challenging as it ought to be, in my experience.
It sounds like you're both in agreement.
Always, except on, yes, actually, I would agree.
On a related topic, can you speak to, circumstances where, from your perspective, certification is or is not always the right path?
Yeah, well, as a defense practitioner, you almost instinctively and intuitively want to, oppose class certification, and you'll hear folks who've been around the block on the defense bar say that that's the whole ball of wax, because if you defeat class certification, you ultimately win the case. But especially when you have opt-outs or folks with their own claims who want to bring them for whatever reason, whether it's the funding or just the fact that the claim is valuable and they can get, they think that there's money to chase. It's what you might get if you file that opposition and succeed is a new set of plaintiffs with a new set of claims who are bringing the same claim. And I actually had this experience. I had a case where defending a law firm client alleged evading and abetting a Ponzi scheme. A group of non-client investors sued, and they alleged basically aiding and abetting the Ponzi scheme. And we got the case dismissed pre-certification, actually on an interlocutory appeal, which is unusual in the United States in federal court. And shortly thereafter, there was a new set of class plaintiffs who brought the same claim. And they just keep popping up, and if you don't get a new class, and there are rules against piggybacking on prior class actions for purposes of statute of limitations, so it's perhaps easier to parry back a new class that pops up, but you still might get new individual claims, and it can just go on and on for years. So one thing that I always think about and try to work into my practice is, do I want to try to maybe file a dispositive motion at the same time as certification is being decided, so the court has an option, if it wants, to certify the class and grant summary judgment, and then the entire class is bound by the summary judgment. And that's not, something that makes sense to deploy in every case, but I do think it's something that always warrants consideration and a little bit of creativity.
Yeah, and just to piggyback on your point, as a plaintiff, I've also had it where the class was not certified, and the defense made a good point, and that's why it sort of got thrown out. But then you have a chance to come back, and you come back with a better argument, and so that can sort of help the plaintiff if you just sort of poke a hole in the plaintiff's theory, like, oh, that is a good point, we'll fix that, and now we'll sue you again. And that can be another sort of avenue where class certification, if you had let the issue go the whole way to summary judgment, you might have won. So you can shoot yourself a little bit in the foot. I agree in that.
That's not to say, of course, that the normal conventional approach is to, not challenge class certification or try to get class certification decided at the same time as summary judgment. It's obviously a risky move. Class gets certified, summary judgment gets denied. Suddenly, you're off to the races in trial against in the U.S. frequently a $1 billion claim, and that's not great in terms of having a settlement discussion. If you want to have a settlement discussion on the eve of trial, facing that kind of exposure against a massive class.
So more of a broad question for the whole group, and probably our last question, we'll open it up for questions from the audience, but from each of your perspectives, defense counsel, economist, and a paying agent, where do you see kind of the following year, a year or two or 5 years from now, where you'll be most busy, what you see happening in terms of types of matters and other themes that you think are coming in the next year or two?
Yeah, I'll start. I think, as I said, we're going to continue to see significant enforcement around tech. There's been a lot of focus recently in the antitrust space on algorithmic pricing, and that being a factor that gives rise to collusion for purposes of an antitrust claim. So I think there will be a lot of that continuing, and tech-related claims, and I think that those will lead to private actions, class actions, opt-outs, and cases by state attorneys general. So that is where I think the focus has been, and frankly will continue to be, more of the same.
I think that over the next 5 years, privacy and generally people's data will be a big driver and really grow. For example, ChatGPT is getting sued by a wide variety of people because ChatGPT uses their data and then it transforms it a little bit and then outputs it to other people. So the question is, does that violate the copyright? Then there's the actual people's, your address, who you are. In America, there's all sorts of firms that you can go to, Spokio, Seamless, and you can look up people and find all sorts of personal information. And they don't ask you if you can be on their website, and it's really hard to get off sometimes, and you can come back on. So I think there's going to be a lot of lawsuits in the future from ChatGPT to people search engines about privacy, who owns the data, and how that gets used. The laws are kind of vague in the US. The laws are sort of behind the times. And I think we're going to see a lot of fighting and precedents being set over the next 5 years over to what extent you own your own data and how other firms can use that data.
Yeah, well, the regime in the United States on that front might become more clear in years to come. I mean, obviously in the EU, it's with GDPR a little bit more clear where the lines are drawn. I agree. It's not super clear in the United States. I also agree we are going to see additional lawsuits in that space.
Yeah, Tim, I agree with both Craig and Michael. And also from a more tactical standpoint, from the payments perspective, and the execution of these settlements, the trends will continue. The settlements will be more targeted towards meeting people where they want to be met in terms of the types of payments they want to receive and can accept. From a security standpoint, that'll continue to be a significant factor in all of this, and choose more secure payment methods to make sure that the end mission is accomplished. And the obvious statement is that we see more and more global work where settlements that are within one jurisdiction now are crossing jurisdictions, and certainly within 5 years, I think this room's going to be much larger. And there'll be a lot more activity and a lot more use cases from in Europe and different jurisdictions here versus just the states.
Mm-hmm. Can you, on that topic, on payments, distributions, can you speak a little bit to the unbanked issue? It comes up a lot. We've heard it a lot. We hear it all the time. What does it really mean, and you know, what is out there, or what will be out there to help solve that?
Yeah, so it's interesting. Again, as I noted earlier, it's a challenge that many of us in this room it doesn't apply to us, but yet when you look at the U.S. population and 20% are unbanked or underbanked, they don't have a traditional banking relationship, and that's not just minorities or disadvantaged demographics. It's young people that transact almost entirely via Venmo and Cash App and PayPal and things like that, and they may not have an actual bank account that they can transact business with. In Europe, the numbers vary. In Portugal, it's actually higher. Portugal is up to 25% unbanked or underbanked. In other areas such as UK or Netherlands, the numbers are lower. But the reality is that if you give someone the option to take money via a mechanism that they need a bank account for, such as a check or even a direct deposit or a PayPal or a Venmo, if they don't have a way to transfer that to a bank account, they can't access that money, and that creates friction in the process, and it reduces acceptance of these settlements. So a great alternative that we've seen, as noted before, are things like digital prepaid cards or gift cards, or things where you don't need an actual bank account, but it's a way, if somebody chooses to select that as a payment option, that they can still receive their funds and spend it wherever they want to.
Is cryptocurrency a possible additional tool to be used in this area?
You know, we get asked that question a lot. I would say likely in the future, perhaps when it's more stable, if it's more stable. Today, we kind of view it from a company standpoint as more of an investor's tool than an actual payment tool. But I would say it's definitely heading that direction. The challenge with crypto, as opposed to some of these other regulated payment types as it relates to the security, is it's more difficult to understand who's receiving it and where it's going. So whereas with a MasterCard or a PayPal or something like that, we can tell where it's redeemed and how it's redeemed, and to a certain extent where it's being sent or spent.
But fraud might go up with cryptocurrency, right?
It would be unknown
right.
at that point. So for that reason, I don't see it as a current option. But I mean that's evolving. So
And it's the volatility too.
and
I
yeah,
assume.
exactly.
Except with stable coins, which aren't always so stable.
Yeah.
Question.
Isn't the whole point of cryptocurrency that there's an open ledger and you know exactly where it goes?
So and this is outside of my area of expertise, but in terms of if I send you crypto, I don't know who you are. I know the back end data as to where it goes, but in terms of how is that money being channeled or funded or what country, I think it gets a little bit more vague there. But it sounds like you may have more expertise in that area than I. Yeah.
And we are, I think, that wraps up the questions I had for the panel. I think we wanted to leave time for questions, so we are ready for questions.
Good morning. Somebody made the comment yesterday that an interesting dynamic in U.S. class actions is you fight like cats and dogs until you reach a settlement, and then all of a sudden you're on the same side and trying to convince the court to approve a settlement. And as a U.S. class action defense lawyer, one of the trends I'm seeing that's very troubling is really heightened scrutiny of settlements. We've always had sort of the objectors who want to come in and get paid off. We now have public interest organizations who scrutinize settlements. The Seventh Circuit has now at least suggested that attorney's fees should be based on payments actually made to claimants as opposed to theoretical payments. The 11th Circuit has banned the named plaintiff award payments. The Ninth Circuit is notoriously difficult. I was just wondering if you could comment on what you see as the current trend, and once the plaintiffs have reached an agreement they're happy with, and the defendant has tried to buy peace, your views on the current trend with getting settlements approved.
Yeah, I do think it varies circuit by circuit. One of my partners actually recently had a settlement class denied by the court, applying the normal settlement factors. But I think generally speaking, there's a case from the Third Circuit called De Beers, and in that case, I'm just going to give a little bit of context on it so everyone understands the point. There were basically class members, some of whom under applicable law, it was a nationwide class, it was an antitrust claim. Some of them necessarily did not have a claim under a doctrine called Illinois BRIC because they were indirect purchasers, and some of them did. And there was a dissent. This was an en banc Third Circuit decision, and the court basically said it's settlement, so we'll let it go. And the dissenting opinion said that this was basically a violation of the Rules Enabling Act because you were taking Rule 23 and making a hash out of Rule 23E, which obligates the court to apply the factors for class settlement to determine if a settlement is fair, reasonable, and adequate. And I do think generally that case is probably at this point over a decade old, but I do think generally that's the way a lot of courts approach it. But I think it is circuit by circuit. I would say, from my perspective as a defense practitioner, when we have a settlement, we're never taking a position on whether the settlement class should be certified. We're not objecting to the court certifying a settlement class because, the factors are the same, and even if they're applied in a slightly different way when there's a settlement versus you're determining whether to certify a class for litigation purposes in some courts. If the court were to, if we were going in and vocally saying, look, this should be certified, there is a risk that I always see that's going to be used against me when the settlement class is denied, litigation continues, and the plaintiffs are seeking certification of a litigation class.
I think the scrutiny of the settlement is critical. There's ultimately a principal agent problem with the attorneys. And it's sort of, the way I like to describe it is a study done by Levitt, who wrote Freakonomics, if you're familiar. And it had to do with real estate agents. And real estate agents, they get a little cut of the percentage of your home price. And what he found is when a real estate agent is selling someone else's house, they put it on the market a lot less longer when they're selling their own house. When they're selling their own house, they leave it on the market a lot longer to get a bigger deal. What they really want is to they want to sell the house. 10% more doesn't get them that much when you have a small commission. And so to avoid this principal agent problem, I think it's critical for judges to look at these settlements and say, this is too low. You haven't gotten a good enough deal for your clients. And, I think the defense and the plaintiffs are sort of on the same teams, but as you mentioned, the defense is more like a silent partner. Everyone's talked, we've argued, we fought, we think we have a deal, but we don't want to say that we think you should accept the deal because that might make us look bad. But I think it is critical because you do have this principal agent problem, and that's part of the reason you see settlements where the settlement's less than the cost of the check. It's because the settlements are getting too low. We should be fighting more. We should be going to trial more, as far as I'm concerned, is that judges should ask for higher percentages of settlements. I see what the actual damages are and what they're settling for, and I think they should be doing a better job in throwing out more.
You mentioned American pipe tolling, and I'm just curious what you think if there's a likelihood that it is dead on arrival if American pipe tolling gets to the Supreme Court again, and what you think the timeline for that might be, if so.
Could you repeat the question, please? I couldn't quite hear it.
Sorry, American pipe tolling. if you, there have been a number of recent decisions from the court that undermine it from various angles, and if you think that stands if it gets to the Supreme Court again, or if you think that the current court will overturn American pipe tolling.
Yeah, I don't know. We've seen a lot of recent Supreme Court decisions dispensing with precedent that has existed for a long period of time. I think it's a mixed bag. Even if it goes out the door, there are other forms of tolling that are applicable, not to absent class members, but you've got continuing violation tolling, equitable tolling of other varieties. So I don't know that it will meaningfully change the game, but in terms of what the Supreme Court will do, I'm really not sure. I think I would say unlikely to overrule it, simply by virtue of the fact that I think it's unlikely to be cleanly presented to the court, given the numerous other forms of tolling available to plaintiff classes and opt-outs.
That's very helpful. Thank you.
Any other questions? Well, thank you. Thank you to the panel. And please feel free to come and grab one of us with any more questions or interesting discussion. Thank you.